Hey everybody, welcome back to the channel today. We are continuing our watch on the roster challenges that we're seeing. Obviously, if you have been paying attention to the news, you'll see that another challenge came down, or another decision rather came down on a separate lawsuit. And we wanted to go through that today. What are the differences? What's the comparison? To do that, we've brought back on Alex Frank from Michelle & Associates. Alex, thank you very much for being with us today.
Thanks for having me back.
Absolutely. And before we get into this, I just wanted to remind everybody we are still on the road to 10,000 subscribers. Hitting the like button, the subscribe button, and the share button really helps us to get to this goal. We're trying to get this information out to as many people as possible. So please, if you could, drop a comment, drop a like, drop a share, and subscribe to the channel. So back to this, Alex, I didn't know that we were going to get you back on so quick. You get that decision with Boland. And then, you figure there's still some more administrative stuff to do, and then it's going to go through the Ninth Circuit. But we did get another update from the Ninth Circuit. Am I correct in saying that with the Boland case specifically?
That's correct. I think when we last spoke, we were writing the briefing in opposition to the state's request to stay the case at the Ninth Circuit. I think I spoke to you the day before, maybe 2 days before. So we filed that briefing last Thursday, which was March 30th. And then the following day, the state filed their reply. And then 4 hours later, the Ninth Circuit ruled on it. And they basically denied, they granted. They denied what we were trying to do. They granted the state's motion and they entered the stay.
So in total here, you've got the challenge to the roster on 3 specific things that Boland did. That was the chamber load indicator, that was the magazine detachment mechanism, as well as the micro stamping. The judge ruled in our favor, but he put a stay on enforcing that law on 2 of the 3, right? Micro stamping is not being addressed here. So you get the state appealing that to the Ninth Circuit Court. They're saying, hey, while we continue to litigate, we don't want to have to enforce these laws, and the Ninth Circuit granted that. So now what do we do? Do we just start the process over again with the Ninth Circuit?
So now what happens? So as of yesterday, the chamber load indicator and the magazine disconnect mechanism, those have not, the injunction preventing California from enforcing those requirements is not in effect. However, the state did not ask the Ninth Circuit to stay the ruling that we got from Judge Carney as to micro stamping, which means that as of yesterday, micro stamping is not a requirement for manufacturers. So any manufacturer that wants to try to retrofit one of their existing semi-automatic handguns to include CLI and NDM would be, if they can do that, they can go ahead and try that, and then they can submit to the labs, and that would get the gun rostered. So that is important. But as far as what's going on at the Ninth Circuit, the order denying, rather granting the state's motion to stay, set out a briefing schedule. So it ordered the state to file their briefing by the end of this month. And then we, the Boland plaintiffs, or now appellees, will have, I think, 30 days to file their briefing in opposition. Then the state gets to close out the briefing with their reply. And then once the briefing is fully submitted, the Ninth Circuit will set an oral argument hearing date, likely for the end of the year. We may see them do it on a more accelerated basis, but there's really no way to tell. It's, there's a lot of traffic in the Ninth Circuit. It's the busiest circuit court in the nation. So we'll see when that happens.
Well, that doesn't surprise me, you saying that. Not only is there a large swath of the American population within the Ninth Circuit, but the Ninth Circuit also seems to infringe on a lot of constitutional rights. So I'm not surprised to hear you say that they're the most swamped. So basically what you're saying is it looks like there's going to be a lot of lawyers doing a lot of writing over the next couple of months. Then we're going to get a scheduled time to hear the arguments in court, probably towards the end of the year. So I was also kind of curious, you get our challenge to the roster is not the only challenge that existed. There and this news is something that circulates. But for those who are unaware, there was another lawsuit, which was Renna Vibanda, correct? And I guess shortly after we actually got the decision on the Boland lawsuit, out comes another decision on a handgun roster for Renna. I'm wondering, can you take us through the history of Renna Vibanda, as well as the decision that came down for that?
Sure. So Renna Vibanda was first filed in late 2020, which is before the Bruin case, obviously in 2022. And that case went through a couple of complaints. I think there were the state brought a motion to dismiss it, and it was sort of not doing a whole lot. And then Bruin happened, and then after Bruin, they amended their complaint to say, hey, we have a new new law that's going to apply to this question. Because prior to that, the case was more or less a duplicate of a case from several years ago called Pena. Pena was a Second Amendment based challenge in federal court to the roster, which went up to the Ninth Circuit and lost. So things changed post Bruin. They brought their motion to preliminarily enjoin the roster, I think, roughly around the same time that we did. It was pretty sure it was after, but they got a similar ruling out of Judge Sabra in the Southern District of California, the same day that the Ninth Circuit granted the state's request to stay our case in our Boland case. So within hours, there was a lot of activity in federal court pertaining to California's roster. Judge Sabra granted the preliminary injunction request. He also went one step further in that he also preliminarily enjoined the deletion provision that we spoke of last time, the 3-to-1 deletion. But in any event, he stayed it pending appeal or pending further hearing in his courtroom, which he put on calendar for April 14th. So he nearly did the same thing procedurally that Judge Carney did, which is that he said, look, this is stayed for now, but you're going to have to seek a further stay from the Ninth Circuit. So I would imagine that this week we will see the state bring the same motion that the state brought in the Boland case to continue the stay pending appeal. Now, because it's April, the panel that will hear that motion at the Ninth Circuit will consist of entirely different judges than the panel that sat on the motions panel that heard that same motion when the state of California brought that motion in our Boland case. So we don't know who's on that panel, but if they're luckier than we were, and they get 3 judges that are a little bit more inclined to respect the Second Amendment, then we may see them just deny it, in which case the key roster requirements would be unenforceable. And I would imagine the state will not be thrilled about that, and they may try to seek an en banc review of that, which means that, like, in between the 3-judge panel that you get at the Ninth Circuit and the United States Supreme Court, there's sort of like there's another, I don't want to call it an appeal, but it kind of functions as an appeal, which is that it's called an en banc review, where you get, I think, 11 judges in the Ninth Circuit to basically redo what the 3-judge Ninth Circuit panel did. I would imagine that the state would do that, and then depending on how that resolves, you might even see them try to go the state, if the state were to lose that, you might even see the state appeal that to the United States Supreme Court. I'd actually have to double check whether or not that en banc mechanism exists in this context or not. It may not, but either way, the state will not be happy about it.
Well, and that's kind of what I was curious about. So you have, first of all, let's touch on this, because the Boland lawsuit was very specific, right? It attacked 3 very specific things within the Unsafe Handgun Act. Was Renna functioning the same way, where it specifically went after these things? Because I was under the impression it was a little bit more of a compilation, well, not a compilation, but a little bit more of a round lawsuit attacking the handgun roster as a whole. I'm curious, is that the case? And if that's the case, how does the judge end up landing on this decision? Is there any way that the Boland decision weighs on that? Or how does that actually work?
Sure. So to clarify, there's really not much difference at all between the broader lawsuit that we filed in the Boland case and the broader lawsuit that the plaintiffs in the Renna case have filed. Our complaint, which is basically what you file to initiate your case, it asks to enjoin, meaning strike down, the entirety of the roster. So the difference between our complaint in the Boland case, which seeks to do the same thing that Renna does, which is strike down the entirety of it, is that we narrowed down the scope for our motion for preliminary injunction just to a few things. Now, the Renna MPI basically duplicated the complaint. They are seeking to enjoin the entire thing.
Okay, that makes sense. So you have a broader lawsuit, and then you file specifically for the preliminary injunction so that they can't enforce the law on those specific things. That makes sense. So where does it go from here? I mean, you have similar lawsuits. I did not know that about the rotating of the 3-judge panel. So basically what you're saying is, you have this idea of the status quo, right? These are laws that have been enforced for over a decade. It was presumed that the Ninth Circuit was going to grant it, but there's always that chance that they don't. Now that you have, the 3-judge panel cycled out, with Renna, you basically get another shot at getting a preliminary injunction and not having it stayed to where we can start functioning without these things on the roster as requirements. So if I'm hearing that correctly, that's awesome, right? So here's the second at bat for doing this while we litigate. Going forward into the Ninth Circuit, I'm curious, do these lawsuits stay separate? Do they always stay separate because they're so similar? Is there any kind of pre-existing thing where lawsuits get joined together, or are they always separate?
That is a possibility. The terminology is they'll become related because they seek the same types of relief and involve the same questions. That will likely happen on appeal. But we'll have to see how that resolves. At the moment, there's been no activity on that, and it's true enough that the questions are the same, and the relief granted is basically identical as far as comparing the orders of the MPI issued in Boland and the MPI issued in Renna, and the Renna opinion written by Judge Sabraw does reference Boland. So there's little doubt that the Ninth Circuit will likely try to condense them into one hearing. So we'll have to see what happens with that.
And I'm just kind of curious, is this, so there have been challenges to the roster before, right? And multiple challenges. Before Bruin, it was pretty slow going. Everything was getting shot down either at the federal district court or the Ninth Circuit. Is this a testament to how effective Bruin actually is in application? I understand this is the first Second Amendment lawsuit, these two, right? And correct me if I'm wrong, these two lawsuits are the first two that have actually been ruled on since Bruin, and it seems like it happened pretty quickly, not just happening quickly, but happening on something that has a bad record in the courts in the past. How big of a testament is this to the Bruin decision and how Second Amendment litigation is going to be going forward?
So there's no question that Bruin has changed the game for Second Amendment litigation, not just in California, but everywhere, the whole nation. Bruin is, it's not a perfect opinion, but it is critically important. And the short answer to your question is yes. It is the reason why things are happening and things are starting to resolve in our favor. Second Amendment litigation really kicked off in 2008 when the Supreme Court issued its Heller decision. And what the Heller decision established was that there's an individual right to bear arms. That means that they rejected the militia theory, right? The idea that Second Amendment text says that the purpose of the right to bear arms is to have a militia. And the Supreme Court, Justice Scalia, writing for the majority, said, not exactly. The militia is the people, and the Second Amendment protects a pre-existing, it codifies a pre-existing right to exercise armed self-defense. And so that was huge, because up until then it was kind of up in the air what the Supreme Court might say. There was some precedent from the early 20th century that suggested that the court might not say that. The Heller opinion is long and lengthy, and it talks extensively about how we know what the framers of the Constitution intended. We know what the broader societal understanding was in the context and all that. And what happened, unfortunately, is that Heller established this test that the courts ignored. And the Heller test was that we look to the text of the Second Amendment and we look to historical tradition to discern what the modern day scope of the right to bear arms is. And it was not unclear. And what happened is that courts basically ignored the Heller majority ruling, and they basically followed the dissent that Justice Breyer wrote. And Justice Breyer's dissent basically said that, look, we have a lot of firearm violence in the country, and this majority test, which doesn't allow us to interest balance the Second Amendment interest in private arms ownership against the police power in experimenting with policies to decrease gun violence, isn't a good test. But that was the dissent, and everyone knows that dissents are not the law. The majority opinion is the law. But despite that, pretty much everywhere in the country, they ignored the Heller majority opinion, and they basically followed the Breyer dissent. And they said, as long as the law doesn't destroy your Second Amendment right to own an operable handgun in your home for self-defense, pretty much everything else is fair game and is subordinate to the state's regulatory power. That was a bastardization of Heller. And there were many attempts to get a new Second Amendment case before the Supreme Court post Heller, telling the court, look, this is not legit. You've got to stop this. But because of the composition of the court, those efforts were all unsuccessful. And that's why Bruin was such a big deal. We finally got a case up to the Supreme Court with a majority, I'd say civil libertarian-minded panel of Supreme Court justices. And they said, look, we were clear in Heller, you didn't follow us. Now we're going to be extra clear. And they were. Justice Thomas, writing for the majority, said, look, this two-step test that involves interest balancing is over. It was wrong. It's been wrong since the minute after Heller, and you're not supposed to do it anymore. Now, we're seeing state governments try to, wiggle their way out. And unfortunately, there's some decisions that have come down that show judges doing just that. They're trying to nullify Bruin the way that the courts nullified Heller, but Bruin is a much more tightly worded opinion, and so courts are having a much harder time, and that's why we're getting really good pro 2A results out of courts. Not everywhere, but we're getting the results that we're getting now in California in this roster situation because of Bruin. So yes, Bruin is very important.
Well, and I'm sure that there will continue to be, especially here in California, there will continue to be arguments by lawyers. There will continue to be attempts to try and wiggle their way out of this one, just like they did Heller. But we're hoping that we bring our arguments as well against those, and the judges actually follow that Supreme Court decision. But we're definitely going to keep an eye on this as it continues to progress. Alex, I can't thank you enough for being back on with us. I really appreciate it.
My pleasure. Anytime.
And we're going to do just that. We're going to keep on winning. We got the good Bruin decision. We're looking forward to many more lawsuits coming down that are already in the courts. Please follow along with us. You can do that by subscribing to the channel. You get a notification if you turn on the notifications every time CRPA TV comes out with a video. Also, please like and share this with your friends. We are trying to get this info out to as many people as possible so that they can understand the efforts that are taking place to secure their rights. Thank you guys very much, and we'll see you on the next one.